So my name is Danny Bradlow. I teach at American University, Washington College of Law. I've been teaching here for about 20 years. I teach international economic law courses. I teach an international financial law course, international organizations course, and then also this course on international business negotiations.
And I'm Jay Finkelstein. I'm a partner at DLA Piper, where I practice corporate transactional law, international corporate transactional law. And I've been teaching as an adjunct professor at American University, Washington College of Law for now about 10 years, where I teach the international business negotiations class that Danny and I have developed.
The big difference, and it's a huge difference, is that in litigation, it's a zero-sum game. Someone's going to win and someone's going to lose, and you want your client to walk out happy and you don't care that the other side walks out disappointed. In a business negotiation, it's a win. It has to be a win-win situation, and so you have to walk out, particularly if it's a joint venture. I mean, you're going to have to live with these people for the next 10, 20 years, and if they don't like what you've done, they're going to look for ways to get back at you in some way in the future. And that's the big difference between what we're doing in this exercise and a litigation, like a trial advocacy course. But in one sense, I want them to see that negotiation is like advocacy, and that the skills that they've learned in their litigation courses are relevant because it's teaching them the same skills. It's adapting what they've learned to new situations.
I normally start the class by telling students that I'm going to teach you how to use the law. I'm not here to teach you the law itself. And there's a follow-on to that, which is, of course, we're going to talk about substantive issues of law. We do have to talk about intellectual property law. We do have to talk about contracting and joint ventures and licensing agreements and supply agreements. But we're going to do that in the context of using the law to document and negotiate a business transaction. At the end of the class, I normally do a summary class after we've done the debriefing, where I say, okay, let's list out and put up on the board all the areas of law that we've had to use during this exercise. And we'll take 10 minutes and I'll get areas of law, and then I'll step back from the board and I'll say, okay, that looks like your entire legal education. We've just applied all aspects of your legal education, with the possible exception of constitutional law, which we don't deal with all that much. And then I say, let's also list out all the business topics we've talked about. And we'll put up another list of topics that related to the issues we had to deal with in understanding the business relationship that we were trying to craft through the negotiation. And we'll examine that, and it actually touches on a large part of a business education. The lesson from that is that you must understand business to be able to function as an effective transactional lawyer. And that point is driven home through the class. Students learn that to function as a transactional lawyer, they must appreciate the business aspects that they're actually negotiating.